Washington. Tom, thank you. Former prosecutor Steve Baric is with us, partner at Baric and Associates. Steve, good to see you. So the judge in this case wants examples. She wants concrete evidence. What would that look like? What suffices?
Well, I think they're going to have a hard time proving that, frankly, because, the Constitution allows for a very vibrant, powerful executive. And I think they would have to show that somehow, some way that Elon Musk is making these decisions on his own rather than acting in a consulting type process, referring these issues to the particular agency and then the secretary acting on behalf of the president. So I think providing evidence contrary to that would be helpful to these attorneys generals as they're trying to stop the president's executive actions. But I think the difficulty they're going to face, they clearly felt that this judge was going to be a favorable venue for them because of some of the rulings in the past. And I think they probably are shocked by the fact that they were unsuccessful. So I think they're going to have a hard time actually going forward, getting the type of relief they want over the long haul. And a lot of it is just because the Constitution allows for strong executive power. And it's going to be interesting. I don't think this is the end of this, but it will be interesting.
The other thing, Steve, as I was looking through some of the judge's comments on this, she said DOGE is operating so swiftly, it's difficult to reach a quick conclusion about the legality of its moves. You wonder if that's part of the strategy, right? Just go as quickly as you can with this, and the law can't catch up.
Well, sure, I think that's one way to look at it. But I think also the fact that we have over a $300 trillion deficit is another factor. I mean, we're starting to have the debt service load be more than our, defense budget. I mean, I think the president views this as a massive national emergency. But, that's part of the difficulty. Going back to the legal question is going in for restraining orders. One of the things you have to show is imminent harm, as the judge talked about, but also you have to show that you'll prevail on the merits. And I think in quick litigation, like a restraining order, it's hard to have the necessary evidence in order to prevail. So I don't think this is the end of this litigation. I think this is just the first step. But I think why they wanted it now was they wanted to stop it. They won't get to the merits on a case like this for another 18 to 24 months. So I think as an attorney, that's your difficulty, right? When you're trying to get a remedy quickly, judges feel uncomfortable with that.
Yeah, and this judge in particular argued that the state AGs were acting on media reports. I think the appointments clause is something, folks are trying to grasp and understand because that's key here. The states argue that there was a violation. So what is the appointments clause, and does the timing of the fact that President Trump came out and said, well, call him whatever you want, he's an advisor to me, if that is a factor in all of this?
So all these confirmation hearings you're seeing now, they're all spurred by the appointments clause, right? The president has the right to appoint individuals to certain positions, and certain positions require the advice and consent of the Senate. And that's why you see things like, when we had RFK's appointment last week, that whole process comes through the appointments clause. And I think what the President Trump is saying in this case is he's not a secretary of a department. He is merely consulting to me. This is an advisory committee or an advisory group. They don't do anything in and of themselves. They refer it to the particular department, whether it be HHS or the Department of Treasury, and they act accordingly. I think it's very clear that there's been a preparation to create a scenario where this president could be very efficient when and if he was reelected. And I think that's what you're seeing now. And I think they've probably done a lot of very thorough legal analysis prior to the president's election. So it's a very interesting legal argument. But I think that's where you're going to see this tension over the next 12 to 24 months. Is Elon Musk, did he have to go through the appointment process, and did he require Senate confirmation?
Yeah, a lot of legal scrambling going on and not much legal precedent for all of this. Steve, thank you, as always.
Thank you.